Hi class, it's Amanda, and today I am going over Rule 8.4 of misconduct. And Rule 8.4a says to violate or attempt to violate the rules of professional conduct. So I brought up Rule 1.4 since I did that for my quiz review, which states a lawyer shall explain a matter to the extent reasonably necessary to permit the client to make informed decisions. So an example of 8.4a would be if a client is offered a settlement amount and they do not know the conditions of the settlement amount, but the attorney brings them in and says, they offered you a settlement, but you shouldn't take it. Basically, that is not explaining the matter in a way that the client can make their own decision on whether or not to take the settlement money or not. It's the attorney making the decision for them, which would violate the rules of professional conduct. Um, the next is B, which is commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, and the example I'm going to use also covers C, which involves dishonesty, fraud, deceit. So for B and C, I looked up Tennessee Code 39, Chapter 14, Part 1, and it's the illegal possession or fraudulent use of a credit or debit card. So A states that a person commits the crime of illegal possession who, knowing the person does not have the consent of the owner, takes and exercises control or otherwise uses the card or information for that card. So say that there is a credit card statement, a bank statement that is in one of the client's folders, and the attorney takes it upon themselves to take that information from their bank or credit card and purchases something with it without their permission. So that would look bad on the lawyer's trustworthiness, as well as he would be engaging in conduct of fraud and dishonesty. Engaging in conduct that is prejudicial to the administration of justice, 8.4d. For that example, I'm going to say there is somebody that is going to testify for the other side, and you offer them money, or they say, hey, if you pay me X amount of dollars, then I won't testify for the prosecution or for the defense. That would be prejudicial to the administration of justice if that person was like an eyewitness or something, and you paid them not to testify. E states state or imply an ability to influence improperly a government agency or official, as well as F. That's going to go kind of hand in hand, knowingly assisting a judge. So for this one, I pulled up judicial conduct, and this could also fall under um, influencing government agency or official. So I brought up Canon 2 of the Model Code of Judicial Conduct, which is a judge shall perform the duties impartially, competently, and diligently. So just to go a little bit more specific with it, we're going to say a judge shall perform judicial and administrative duties competently and diligently. A judge shall cooperate with other judges in the administration of court business. So let's say for E and F that an attorney comes forward to the judge and says, you know, my client's innocent and you really don't have to listen to the other side. So kind of just tune them out because I'm going to win this case anyway. And that would not be doing his diligence to both sides. He wouldn't be um, performing his duties without bias I guess you could say. And then G, engage in the conduct that the lawyer knows is harassment or discrimination. So, for example, if an attorney is at work in the office and says, well, I'm not going to take this person as a client because they're Muslim and they could be a terrorist. Well, that could be discrimination. Or if an attorney goes up to a coworker and harasses them about their race, disability that they have, the fact that they're gay, that also would fall under 8.4G in that engaging in conduct that's known as harassment.